Good morning, members. We formed a quorum. I call the meeting to order. Item 1, information papers issued since the last meeting. Since the last meeting, the Secretariat sent out one information paper to you. Please note the information on the latest agenda issued on the 16th of July. Items for discussion at the next meeting. We have got a list of outstanding items for discussion from the Secretariat. Paper CB bracket 1 39/2026 bracket 01. For the regular meeting in October, the next regular meeting will be held at 10:45 a.m. on a Monday, 26th of October. The administration proposes that depending on the date of the delivery of the policy address of the CE, we'll be having a briefing from the Secretary for Labour and Welfare in relation to the policy address to be delivered by the CE for 2026. Any comments? No. Next item, legislating for improving the work injury compensation mechanism for digital platform workers. Please invite the public officers to join us. This is a legislative proposal. Therefore, all other council members have been invited to take part in the discussion. For those who would like to speak or ask questions, please press the request to speak button. First of all, I'd like to invite the Secretary for Labour and Welfare to brief us on the paper CP bracket 1839/2026 bracket 02. The administration will assist us with a PowerPoint presentation. Mr. Sun. Good morning, Chair. Good morning, members. Together with the Labour Department, I would like to brief you on legislating for improving the work injury compensation mechanism for digital platform workers, DPWs. The Chief Executive announced in his 2025 policy address that the government will improve the work injury compensation WIC mechanism for digital platform workers through legislation. And we will be covering food and delivery services. After more than a year's deliberation, the Tripartite Committee for the Digital Platform Industry will introduce legislation following the following principles. First of all, the compensation for either injury or death will result in compensation. There must be a clear legal foundation and certainty for the coverage, items, and details of compensation. We need to strike a balance. On the one hand, we need to enhance the protection for platform workers. On the other hand, we have to consider the affordability of platform operators as well as the emerging industry of digital platform services can have sustainable and stable development in Hong Kong. We believe that we have already achieved a balance. Finally, the implementation arrangements must be simple, easy to understand, and administer. So these are the three major principles. Let me once again emphasize that for digital platform workers and digital platform operators, there isn't an employment relationship. Had there been one, we don't have to raise this issue today. Since there isn't an employment relationship, therefore a lot of provisions under the Employment Ordinance or the Employee Compensation Ordinance do not apply to them at all. For the existing legislation, of course, it has become a starting point for us and it is of reference value, but it's difficult to just copy them. Had it been that case, it would have been much easier for us. It is something new, and therefore we have to be practical and we have to take into account the features and come up with new arrangements. This is a point I want to share with you, and it is a matter of holding a dialogue. It is a new scenario, and we need to talk to the representatives of digital platform workers to look at the protection they look forward to, and we need to talk to the platform operators. We need to understand their operational difficulties, and if it is found to be non-sustainable, we can't force it on them. Therefore, we try to achieve a broad consensus to take the matter forward. We believe that this can be done, and we have also made reference to the existing legislation in Hong Kong. We also drew reference from experience elsewhere. And coupled with our local features, we want to come up with a set of arrangements as soon as possible. I'd like to defer to Mr. Lee Chi-chung Simon, Assistant Commissioner. He will walk you through the paper. I would like to defer to Simon. Yes, Assistant Commissioner. Thank you, Chair. Yes, I would like to talk about the legislative framework for improving the WIC mechanism for DPWs. Just now, the Secretary already mentioned that we followed three major principles for the new legislation. First of all, for the compensation mechanism, we'd like to provide a clear legal foundation and would like to enhance the protection, while at the same time, we need to consider the affordability of platform operators. And thirdly, the arrangements and the operation should be simple, easy to understand and administer. In order to have a legal foundation and certainty, so in relation to platform operator, platform worker, and managing performance of tasks, there will be definitions. For platform operator, it means that a natural person or a legal person who sets up an application for providing platform services as specified in the legislation to service users. At the same time, it will be by means of automated matching of service users and platform workers for the provision of services by electronic means. And thirdly, the operator manages the performance of tasks by platform workers. For platform worker, the definition is as such. He is a person who has entered into a platform work agreement with a platform operator, and he must register work account with the platform operator. And service can only be provided after approval has been given by the operator, and he receives remuneration in accordance with the relevant platform work agreement. And the performance of tasks in platform work is managed by the platform operator. For managing performance of tasks, again, we have a definition. There are two legs here. First of all, the platform operator adopts an automated means for specified purposes, and on that basis, the operator will make use of the data of the workers with the service users. Say, for example, the operator will determine whether platform workers are eligible for providing platform services, assigning tasks, and determining the remuneration of the platform workers in each task. Secondly, there will be imposition of specific restrictions by platform operators on platform workers, like requiring the workers to comply with rules prohibiting or restricting workers from negotiating core service fees with service users or setting up their own clientele, and prohibiting or restricting workers from choosing the number of working hours or the number of tasks they perform, or giving incentives to or imposing penalties on workers in a systematic way on the basis of their performance. Well, in relation to the coverage of the new legislation, we will set out the following. If a DPW suffers injury or dies as a result, he will be entitled to compensation. So the accidents to be covered must take place during the work period and arising from discharging the platform service duty. And so we identify or define the work periods covered in the legislation. It will start at the time when the platform worker starting to depart for the designated location to perform a pickup task. And if he as well as the food and goods having been delivered to the designated location or the specified period of time in case of cancellation of order. And it will cover the period of time the platform worker is on the way back to the vehicle used after the delivery of food or goods. So this will be the work period to be covered in the legislation, and the worker is entitled to compensation. Would also cover the adverse weather conditions. Regarding the protection under adverse weather conditions, unlike employees who are generally required to work at designated time and location, and platform workers may in fact be entitled to compensation before he commences work. Therefore, we do not believe that there should be a separate mechanism for WIC. But then if the worker, having delivered the service and within 4 hours, and then he moves back to his own residence from the place of work, that is just like an employee coming off work, and on the way an accident happens, and as a result of the adverse weather conditions, a tropical cyclone warning signal number 8 or above has been issued, or there has been red or black rainstorm warning signal hoisted. And if there is an accident and should there be an injury or death, then the worker is entitled to WIC. Also, when extreme conditions have been announced by the government. And compensation items. In the case of injuries, there will be compensation for temporary incapacity, that is payment for work injury sick leave, and compensation for permanent incapacity when that has been confirmed, and then medical expenses arising from the injury. And then the operator must reimburse the worker in relation to the medical expenses. And should there be the need, the cost of prostheses and surgical appliances should also be reimbursed. In the case of fatal cases, the operator is responsible for the compensation for death as well as the funeral and medical attendance expenses. In addition, the worker may not be a sort of steady worker may not be a full-time worker for digital platform work, and he may be working for a number of platforms. So we do not intend to cover occupational diseases in relation to platform work in the new legislation, because we have no basis to consider and determine whether there is any specific type of disease that is attributable to platform work performed. For earnings, we do have a definition, and that would determine the amount of compensation. Earnings of a platform worker refers to all sums paid to the platform worker by a platform operator in accordance with the platform work agreement, including but not limited to service fees, tips received via the platform, and cash bonuses under the platform reward programs. However, it does not include reimbursements for expenses incurred by the provision of services or tips given directly by service users to platform workers, or fees negotiated between platform workers and service users for provision of additional services. If a platform worker also engages in full-time or part-time non-platform work, the earnings from such work will be excluded in the calculation of WIC. Calculation of WIC. Many of them carry out the work on a casual basis. And so similar to the ECO, that is Employee Compensation Ordinance, when we talk about compensation for temporary incapacity, we have got the minimum monthly earnings under that piece of legislation, but this will not be applicable to WIC for DPW. But then in the case of death or permanent total or partial incapacity, we do apply the minimum amount of compensation as well as the monthly earnings ceiling under the ECO to the case of digital platform workers. Well, in the case of an injury, in the case of an accident, if the platform worker is working for multiple platforms at the time of work accident, the platforms involved shall apportion the liability for compensation.
The new legislation will also identify the responsibilities of platform operators. So, because of the special features of these operators, they have to notify the Labor Department of their platform businesses. They have to take out statutory WIC insurance for their platform workers and to notify the platform workers about the relevant new legislation arrangements. Number 3, they need to report work injuries sustained by their platform workers to the Labor Department. Number 4 and 5, it's about the maintaining the records of platform workers and workers' work and earnings and provide a breakdown of earnings to platforms workers on a regular basis. So it allows the future arrangement for the claims. So they need to keep the records. In regard to handling the claims, the mechanism is similar to that for handling employees' work injury cases. So after knowing the incident, the platform operator must notify the Commissioner for Labor through the specified form within the specified period in accordance with the new legislation. Due to the flexibility of the platform workers' work style at the moment, we require the platform workers to report to the Labor Department their work injuries within the specified period as well, and to declare and sign that the information provided is true. Also, the platform operator may require him or her, the worker, to undergo medical examination conducted by a registered medical practitioner, a registered Chinese medicine practitioner, or dentist. If a worker fails to submit him or her for such examination, then it may affect his or her right to WIC. On the 2nd of May, we have introduced this legislative framework to the Labor Advisory Board. The government will continue to discuss with the tripartite committee on refining the legislative framework. Thank you. We invite all of you to comment on this. Thank you. Now I'd invite all the council members to comment. So, Shiu Ka Fai, Loether Lam, Ken Wong, Chan Pui Leung, Ng Wun Kit, Cheng Pui Kong, Chao Siu Chung, Elvin Lee, Lam Wai Kong, Kingsley Wong, Chen Chao Kwong, Lam Chen Sing, Ken Lee, and me, myself. So in total, there are 14 members because this required the legislation. So we have a little bit more time, but please also keep it short and brief. Thank you. Mr. Shiu, please. We must know that this mechanism is a good protection, but we must know that the money is actually coming from us as well. So you know that the money may cost $100 million to pay to the insurance company, and it may be a huge expense to the company. So how many platform companies are there at the moment? How many platform providers? As I know, there are only 4 platforms for food. Do you include the other van delivery service? Okay, I'll respond to the first question. I think at the moment, we may not worry about too much about the cost, because the cost will highly depend on the compensation items, and we are still discussing on it at the moment. Although according to the existing standard, it may incur a very high amount of money. But at the moment, we are still under discussion. If we need to provide a good coverage to protect the workers, for sure the cost will be high, but we would seek for a reasonable amount of money. So our priority is to provide the protection to the platform workers, and at the same time considering the affordability of the platform operators. So for the compensation items, we surely need to take into details. For the second question, I'll pass to my colleague. In the tripartite committee, we have been discussing the platforms in the market that is pretty more active. But the legislative framework, we have not set a limit to the numbers of these platforms. So we invite all the platform operators who fulfill our definition on platform operators to register with us so that they can be protected under this mechanism. Thank you. I think the entire scheme, my biggest concern is to make fraud claims, because as you mentioned, they need to go and sign and declare that this is true. But because there are no employer to monitor what's going on during their service, say for instance they said that they have injured their back, we have no way to chase whether this is something that happened during the service. So as you mentioned, there are different, as mentioned, that it should be split among different platform operators. But say for instance, if he have rested for a long period of time, but then he only worked today and he got injured, then how are we going to compensate him? Because in the previous maybe 60 or 90 days, he has not served in any platforms. Maybe I get back quickly. As I mentioned earlier, we are all worried about the long-tailed cases. Our new legislation have measures to cope with these long-tailed cases and put these under control. There are a small number of cases, but very important. Thank you. Next, Mr. Lam. In principle, I agree with the protection mechanism, because these workers have all been claimed as self-employed workers and often not being protected, including mainland Singapore and other countries have the protection mechanism for these platform workers. And this is important in our long-term economic development. I think considering the platform affordability is very important. In regards to the legislation, I have a few questions. The first one is cost, you've mentioned. The second question is about the moral issues. Whether the workers will misuse this claim system. The next question is about the splitting of the cost where if a worker are working for different platform operators. Also, if I would like to ask, what is your consideration factors on splitting the cost rather than only focusing on the sole operator regulations? I would also ask about the work plan. How would you launch these regulations and legislation? So as I responded earlier, when we are designing on the concrete compensation calculation, we definitely will put into account of our moral hazards. Maybe I'll pass the time to Mr. Ho. Regarding the platform operators that's involved, the actual proportion and arrangement, we have a plan, but we are still deciding. We still need to refine it with the tripartite committee. We need to come up with a consent. In terms of legislation, will there be a transition period or an implementation stages? It will require us to learn about the details of the compensation items to decide whether we will launch it in stages. So we can only have the concrete procedures and the exact calculation by then. We would need to take a look at whether we need to add in any subclauses after the big framework and details are confirmed. If we have some technical issues, we will launch it in stages. Thank you. Mr. Ken Wong, please. Thank you, Chairperson. I support this improving the work injury compensation mechanism for digital platform workers, but I do have some questions to follow up. As the document stated, the platform operators have to purchase the insurance for the platform workers. I would like you to respond on the insurance scheme and coverage available at the moment for these workers in the market at the moment. Also, are there any other insurance package that covered particularly these group of platform workers? What is the difference between the existing ones and the ones that we are suggesting at the moment? Will there be a list of insurance companies available so that it may enhance the transparency to the workers and operators? Thank you.
Thank you, Chair. I think it's a matter of the concepts. Currently, there isn't any statutory requirement on the part of the operator to take out statutory insurance for their platform workers in relation to WIC. I think some of them have taken out some insurance on their own. I think they are accident-related insurance. But then in future, it will become statutory. The coverage as well as the amount of compensation will all be laid down in the legislation. So the operators have to go to the market and take out the insurance with insurers as approved by the insurance authority. Currently, we haven't got the legislation, so there isn't such options available in the market. So you insurance companies that are in this field will certainly offer the products, so-called whitelist. I think you're referring to those approved by the insurance authority. Insurance authority will be responsible for regulating the insurers. Our duty is to have a clear legislation foundation, setting out the coverage items as well as the calculation, and then it's up to the market to say what the size of the premium will be, etc. Mr. Chen Pu-Leung, I'm a non-panel member, but I'm interested in this topic. That's why I attend today's meeting. This is going to be a new piece of legislation. After you have drafted the legislation, I think there will be quite some changes in relation to the actual implementation details covering the operation of the mechanism. Now, there isn't an employment relationship between the operator and the workers, so they have taken out a written agreement, and that would be the basis of the compensation and protection. So the worker will carry out the delivery service himself. Well, maybe someone will accept the task assigned and yes, sub-assign it to his agents. We want to eradicate the scenario of illegal workers, but in fact, the workers may sub-assign the task to somebody who is his sort of subordinate. Now, for this mechanism, it is a no liability case, and even though we have got illegal workers, the court may still rule that the compensation applies. In this way, I'm afraid we are not going to eliminate illegal workers, because that would increase the amount of compensation in total as well as the premium to be paid. So what are we going to do with this? And then mention has been made that for the apportionment of the liability. For the apportionment, I think other than the platform operators who will have a discussion among themselves, I think you must have a set of principles, and you can't just leave it to them to have a consensus among themselves. Well, in fact, the apportionment would also involve the case of insurance. If you have got different platform operators, then different insurance companies will be involved. And whether the funds are adequate, that would also affect the amount of compensation given out. So can we make sure that the insurance to be given out, to be taken out, will be adequate in the light of their earnings as well as the number of employees? For the EO and the ECO, we do have such requirements. For platform services, can we have a similar requirement to make sure that their sort of insurance is adequate? Because if the amount of the insurance is inadequate, it will result in a lower level of compensation to be given. And then for the apportionment, if there is a dispute among the platform operators in relation to the ratio, is there a mechanism to sort of have mediation among the operators? Well, thank you for your questions. For illegal platform workers, please refer to paragraph 12. If the court thinks that an illegal platform worker sustains an injury or dies while performing platform work in accordance with the agreement made with a platform operator, the court, despite the fact that the person is not entitled to have the right to work in Hong Kong, may still rule that there is compensation. But then it's a matter of the worker having signed an agreement with the operator, but the operator hasn't ascertained whether he has the right to work. Well, if it is a different case, like the worker who assigns the work further to a subordinate, then of course it is a different case. The illegal worker should be arrested as well. So we can say that with this new mechanism, the platform operator will make sure that there will be investigation, and then the workers are all entitled to work, and then there won't be illegal workers. So it is the responsibility of the operator to ascertain whether the workers have the right to work. So we believe that this mechanism can help us to better control the scenario, because it has often been said that many digital platform workers are illegal workers. They don't have the right to work. Commissioner, in relation to the apportionment, yes, we have a consensus, and we have also got some ideas. While we are drafting the legislation, we hope we can arrive at a final consensus. In that case, we'll have a clear methodology to apportion the liability for compensation, and that can reduce the disputes. For the responsibility to take out insurance, this will be spelled out in the legislation. The operator must take out insurance to cover the possible accidents and therefore compensation claims arising from their service. Any follow-up? Let me think about it first. Mr. Mungit, I agree with the administration. That is, we need to legislate for WIC, for DPWs. 2 points here. First of all, you have got a definition for managing performance of tasks. Say, for example, through automated means in relation to the assignment of tasks, and also restricting or prohibiting the platform workers from establishing their own clientele. Are you worried that operators may change their model of work slightly so as to evade the responsibilities imposed on them as a result of the legislation? Now, the earnings would not cover the tips given by service users directly to the DPWs. Are you worried that the service users will be encouraged to tip the workers directly so that the operators can avoid the responsibility? Well, we need to come up with the definition of platform operator. And then for the automated means, there must be a requirement concerning the assignment and the acceptance of tasks. I don't think the operators would evade the responsibilities, and they can't sort of avoid having such automated means. So the operators that we have in mind will all be covered by the new legislation. For earnings, we're actually talking about the earnings, that is earnings paid for the service delivered. For tips, I don't think the new mechanism would discourage the tipping by via the operator. vis-a-vis direct tipping by the service users. Mr. Cheng Pui Kong. Well, I think the operators would rather have group personal accident insurance rather than having a specific WIC insurance arrangement. I have also asked around the platform workers delivering takeaway food. I was sad, having heard their stories, they really want to have the protection ASAP. I did ask the platform workers. Platform workers, upon my inquiry, said that their service fees, even though might be further reduced, he would still be staying in the trade. 9 hours, but only $680 a day, and he's riding his own motorbicycle. If the earnings are to go down further, what he can come up with is to work longer hours. It is said that there should be regulation of the assignment of tasks. Now, the workers are paid per task. Some operators may say that for the same location or for the same company, the tasks would result in a smaller amount of earnings. I believe that the government must be thorough in gathering the data. If the operators see escalation of their operation costs, then the DPWs may see a reduction of their earnings or even losing their job. If the cost is to go up slightly, I think that can be absorbed. If not, then DPWs will stand to suffer. So you need to be clear about that. And then a word about the insurance. With the introduction of the WIC insurance, do you think the operators will be more choosy? Say, for example, a rider may have had records of traffic accidents, and they will not be sort of welcomed by the operators, or elderly DPWs may not be welcomed by the operators. As operators may be worried that such workers may result in a higher level of premium. And then for workers waiting for tasks to be assigned, that period of time should also be covered. And then many workers are relying on electrical bicycles, which are yet to be legal in Hong Kong. If someone rides such an electrical bicycle and yet gets involved in an accident, will he be entitled to compensation? Secretary, a lot of questions there. Let me cover them. As you know, from the beginning, we say that we would like to have a statutory WIC mechanism. We need to strike a balance. I know operators are worried, and that's why they have approached lawmakers. But then we won't be biasing any party among the two. The status quo is unsatisfactory. Workers believe that their current protection is inadequate. If operators would just continue with the present arrangement, it is unacceptable. Workers must have their protection enhanced. But then at the same time, we know that the new mechanism cannot go too far. Otherwise, the platform economy can no longer be sustainable. So it's a matter of controllable costs for the operators and protection for workers. We need to strike a balance between the two. It is no easy task. If you go too far, workers cannot secure jobs, and we are working hard to achieve the balance. We have said that we must have new features. We cannot just copy what we have already got under the traditional model. We need to be realistic and practical when we try to drop the new legislation. Here we are mainly talking about WIC, so we won't be dealing with the assignment of tasks on the part of operators. Otherwise, the job cannot be completed. So we're focusing on WIC. Mr. Chen Pui-leung is more knowledgeable about the insurance. When you take out the insurance, the individual workers are not identifiable. You don't know who the age profile of the workers. But then if too many workers suffer injuries, then of course the premium will go up. But then if everybody has a safety awareness, then the premium may come down. So maybe Mr. Chen can also assist. And then there's one other point that I may want to cover, and it is in paper as well. That is paragraph 13. We have got the no-fault principle. In other words, for their means of transport, even though it is not yet lawful, but then since we adopt the no-fault principle, compensation will still be given out, except that he has had taken drugs, or if he's drunk, he's under the influence of alcohol, then there won't be any compensation. On the other hand, if he's sober, but he may be adopting a means of transport that is not entirely lawful and he suffers injury, then just like what we have got under the ECO, he will be given compensation. So other than using a means of transport, if someone uses a proper means of transport, but then if he doesn't obey the traffic rules, he will still be entitled to compensation.
Because the time is limited, so I'd like everybody to keep your comments and questions brief. Thank you. Mr. Chow, please. Thank you. The administration for launching this or proposing this, because these platforms' operation has been arising in these few years, and we are now already having a legislation to protect these workers. From my experience of working in the labor union for decades, it may take 10-20 years for something like this to happen, but I really appreciate the administration's effectiveness this time. According to our secretary just now, we've mentioned about the protection that we are launching, and we're taking reference from the Singapore's practice at the moment. We have this no-fault principle, and also we are not considering their years of experience. In terms of the calculation of WIC and the formula, I believe you already have a principle or standard to follow. And these should be taken close consideration when we are formulating the details. As you mentioned, you're saying that there are some plans or measures that are under discussion and you already have plans, but it's not convenient to share at the moment. So, say for instance, for the apportionment for liability, for compensation, I really hope that you can share a little bit more with us so we get to know better. We understand that there's no minimum monthly earnings under ECO. This is not applicable here. But will there be also a maximum amount of compensation of monthly earnings that for your consideration? Because say for instance, I've only worked for 2 days and I already experienced a death. So how can I compensate? Because we don't have any previous monthly earnings as reference. Say for instance, in this case, if there are no compensation for this case under this new legislation, then why would I consider this new plan compared to the existing insurance plan? It could be even worse than the accident insurance package that I purchased for myself. So I would like you to focus on this as well. Number 3, I know that we need to register to these operators. And these operators should register under the Labor Department. But if these platforms do not register under us and they recruit workers to work for them, when there's accidents, who are going to take up the responsibility? Last but not least, about the insurance in paragraph 18. If the platform worker is working for multiple platforms at the time of work accident, if the question is, working for multiple platforms, does it mean that when they are making the trip and serving 2 companies is considered working for multiple platforms compared to, or does it mean that I have registered in 2 platforms? I would like you to clarify it. In response to your first question, because this digital platform industry is a newly emerged industry, it's a bit hard to use the employment compensation at the moment. We did take reference from it and also take reference from the Singapore practice, but we also need to make adjustments according to our own context, and also to protect us from not falling into the moral hazard traps. So say for instance, if a worker claimed that they've injured, this is also one of the moral hazards, and we cannot rely on the employment compensation at the moment. We have to study in multiple layers. Also, if the platform operator fulfilled all the requirements of us, but then they don't come and register with us, then for sure it's their own problem and they are operating illegally because they should register under us. Regarding the apportionment, if they are delivering the trips for both food delivery platforms, then of course it's split among the 2. When the platform worker is injured and he is only serving 1 company at that time, then the platform operator should bear all the responsibility. But in terms of the proportion, then they need a further discussion with these platforms. We do have a plan, but we need some time for discussion. Thank you. Next, Mr. Alvin Lee. I agree that the government should launch this. And I also agree with the principles to balance the 2 parties. Under the legislative framework, we have discussed a lot on the details already. But what I would like to understand is what is the reasons behind this legislation. Just now, as you mentioned, it is different from the employment compensation. So I believe our society will definitely compare the two. So being focused, the digital platform industry, will there be other implication on other new emerging industries? I have a few questions. Regarding the coverage, regarding the occupational sickness, you are saying here that there's no plan to make provisions on these because it's hard to define. I would like to know your concerns and challenges in this. The next question is the working time of the workers. The working time also includes the waiting time when you are claimed that you are online. Will the waiting time be counted as well? How are you going to protect the working time and hours? How do we define the working time? Is it according to our usual practice or according to the platform practice? Thank you. Later, I'll pass the time to Mr. Hui for the occupational disease. Regarding the work period under the coverage, we do not cover the waiting time because this exactly reflects the feature of this digital platform industry. Because when you're waiting, different from how we work in office, when we're waiting, it's under everybody's monitoring. Different colleagues are checking on each other, but then for digital platform, it's difficult for us to monitor what they are doing and where they are at that moment, and it may lead to a high percentage of moral hazards. So if they have already closed their go offline and they try to claim for the insurance, then we'll give because it's reasonable. Regarding the occupational disease, according to the professionals, it is related to the long-term exposure to the work or job nature and lead to some occupational disease that took place inevitably. So the identification of occupational disease and the job nature takes time and experience to identify. As mentioned earlier, the flexible pattern of these workers may have multiple jobs apart from being a platform worker. So it's a bit hard to define and have clinical evidence to show that such occupational disease is related to a certain job nature. So at this stage, we think that we will remain an observation first before we include this under the legislation. Thank you. Mr. Lam Wai Kong, please. I'm really grateful that the government has legislate this to improve the work injury compensation for digital platform workers because they are not employees, so they are not under the existing one. So I have some suggestions. Do you have an arrangement on main legislation? So say for instance, something that is similar to the existing terms and regulations to protect, and under the subsidiary legislation, we differentiate between the digital platform workers and the other workers. Will they be able to have an enhancement on this? The second suggestion I have is regarding the calculation of the WIC. From our labor union and other workers' reflection, when they are online or offline 1 hour before and after, it's also included under the existing insurance. But after the legislation, the insurance coverage seems to be less than now. Some platform workers also suggest that their main salary income rely on this platform. If the documents that they submit, we can see that they really highly rely on this platform working income. And will it be possible to have a proportionate arrangement for them so that they are under greater protection? Thank you.
Well, Mr. Lam has been considering the finer details. Of course, we always have the principal legislation setting out the principles for the actual operation, like methods for calculating the specific amount. We always have schedules, or we have subsidiary legislation. Well, just now you talk about the work periods to be covered. The legislation has to be clear about that. Well, the legislation talks about the need to take out statutory WIC. Now, currently, operators are taking out accident insurance. The new legislation doesn't preclude anybody from continuing with that practice. It's up to the operator to make such a decision. A worker may work for a number of platforms. Even he may be working mainly for a particular operator. Well, of course, we talked about a multi-pronged approach and a multi-layer arrangements. If it is found that a worker works predominantly for a particular operator, then it is hoped that the operator will be mainly responsible for the compensation. And maybe we can have factors to cater for cases in which a worker only works scantily for a particular operator. Mr. Kingsley Wong, I welcome the move to legislate to enhance the protection for DPWs. So I must give recognition and with great sincerity to the administration. For WIC, DPWs are sort of grassroots workers. I think they should be treated in the same way as any other employees. Now, I would like to make 3 points. This arises from my discussion with the labor sector. First of all, the work periods. Now, currently, it is 1 hour before getting online and 1 hour after going offline. Now, for the ECO, employees are covered when they are on way of work. So can we have the same for the DPWs? It is in particular for workers having delivered the goods or services. When they're on the way back, they are still online, but then when they are at a location waiting for tasks, they go offline. So if they are waiting for the task to be assigned, I think that should be covered and it should be clearly spelled out. I think you need to be at a particular location to go online. So can you not consider that? So that once they get online, they will be covered like an employee on the way to place of work. We have encountered cases in which a worker may get involved in an accident after delivering the goods or services. There are cases in which compensation would not be given, like under the influence of drugs or alcohol. Now, for the South Asian workers, some of them may not have learned how to ride a motorcycle, but then they might be able to obtain a driver's license by post from their home of origin, and then they get a Hong Kong license on that basis. The ICAC made a few arrests. So what would happen if there should be such improper acts and yet there is an accident? So are you going to work together with the TD so as to eradicate the existence of such bogus driving licenses? And then in the case of death or permanent incapacity, you have minimum amount of compensation and monthly earnings ceiling under the ECO being applicable to the compensation payable. It is said the compensation comparable to those of employees. I understand within that framework you have got 48 months, 72 months, and 96 months respectively. Would you be having the same or simply just comparable? Commissioner can take up the questions. When the Secretary answered questions from from other members, the answer has already been given. Well, for the work periods to be covered, well, a worker may be online, but as to what he is actually doing, he's not regulated. It is beyond the control of anybody, and the worker has full say over what he is doing and what he can do while waiting for tasks to be assigned. So there is this worry about moral hazard. We do have clear provisions about the protection as to what the operator can offer attractive terms and conditions to attract workers to work for them. It is a matter for the operator. If the operator is willing to cover those periods as well, we don't prevent them from doing so. For bogus driving license and other forged documents, well, since we have the no-fault principle, despite the use of bogus documents when there is an accident, there is still this liability to protect the worker. But of course, I must add a rider here. That is, when the court determines the amount of compensation, the court may consider the personal sort of responsibility of the worker himself, and then the amount of compensation will be adjusted accordingly. So it doesn't mean that irrespective of the illegal acts carried out by the worker will have no personal liability at all. That won't be the case. And then for bad habits or unlawful practices of the workers, so it is a matter for other departments to enforce the law. So maybe Mr. Wang's concerns can be referred to other government departments to see how and if they can deal with them. In paragraph 20 of our paper, mention is made about the amount of compensation to be calculated for death and compensation for permanent total incapacity. We talk about the compensation being comparable to those of employees under the ECO. We believe that most of the methods of calculation will be similar or comparable. So we say that the compensation will be comparable. Would it be 100% identical? Well, that's the direction of our thinking. But of course, we need to have the overall legislation before we can really say so. Mr. Chen Cho-kwong, for this proposal, I need to commend the government for the operators, the workers, as well as the management of tasks. I think you have got very good ideas here. Many other members have already asked the questions in my mind, but still I can tell you that there is a trend I have spotted in this industry. Even for illegal workers, they get covered. But then I know that there are sort of workers who get tasks assigned. I think if it is a matter of sub-assignment, they would not be covered. I think he's right. No entitlement. Now, even if you are an illegal worker, and you have signed an agreement with the operator, that is, the operator has accepted you. So if somebody illegally assigns his work to somebody else, the person who receives such a sub-assigned task, of course, he won't be entitled to compensation. I think you need to step up the publicity. I think a worker may not know that he's not entitled to compensation. In the case of an injury, should the sub-assigned worker go after the person who assigns the task to him from the operator? Once we have got the legislation in place, I believe that while we will publicize the message, the operators will also be very concerned about it, because if they don't manage it properly, the premium will go up and the competitiveness will be affected as well. Mr. Lam Chun Sing, please switch on the microphone for him. Mr. Lam, sorry. I was attending another meeting next door, so if my question has already been asked and answered by the Secretary, you can be brief. We are grateful to the Labor Department. We, under our trade union federation, got a association for the food delivery services, and we have got many South Asian workers. We're grateful that our suggestions have been taken on board. Well, it is said that there will be compensation for temporary incapacity, that is payment for work injury sick leave. It is a matter of 4/5 of 2 years' earnings. That's under the ECO. Can DPWs be entitled to the same kind of compensation? It is a matter of 4/5 of the earnings. But then if the work hours are short, then 4/5 would result in a smaller amount. Now, for short working hours, it means that they have got fewer hours available for getting tasks, and then the compensation will be small. If it is to go below 4/5, like 2/5, for example, then the compensation to be given will be even smaller. So perhaps irrespective of the working hours, you should adopt 4/5 as the basis of calculation. And then compensation for occupational diseases. I understand that it was a question already asked. For you to prove that there is occupational disease, there are vigorous requirements, and it is difficult to feign that you have occupational diseases. But then for DPWs, they may suffer from injuries or as a result of carrying a lot of heavy goods, and they may suffer hand injuries or arm injuries. I want to know whether you can cover that kind of risk as well. There's one point not clearly spelled out in the paper. That is for the WIC. I want to know whether you have the same arrangements for calculating for the 872 or 96 months work or earnings. And then for the funeral and medical attendance expenses, will be the same as those under the ECO for employees.
Thank you. I would regard to the first question, and I'll pass the time to Mr. Hui for the other two questions. When we are deciding on this legislation framework, we understand that this is a brand new industry, and we cannot copy everything from the ECO to this industry. It can only be taken as a reference. There are some adjustments needed, and something it's not applicable to this industry workers. So, from what we see, I can't see the possibility of using a standardized formula to calculate the compensation for the ECO and this digital platform workers. So we need to work with a multi-layered approach. For the details, we need to discuss with the stakeholders. Maybe I invite Mr. Hui to share on occupational diseases. As Mr. Lam mentioned, I have responded earlier. It's the diagnosis of occupational disease. It requires a medical relationship between the disease symptoms and also the job nature. So, with regard to this relation, although it takes time and experience to diagnose, we don't exclude that there could some symptoms or caused by this delivery work. So, if this is the case, this will fall under work injury, and we will have relevant compensation. But occupational disease, it's rather a complicated and complex concept, and it's a bit hard for us to make any provisions at this stage. Next is Mr. Ken Lee. My concern is the new industries emerge from the digital age. We see that the digital platform industries jobs or work nature are emerging differently at the moment. Regarding our moral concerns, for example, they only work for 1 to 2 days. I would like the administration to take consideration on these potential moral hazards. I would not like you to focus too much or worry too much on these and leading to not being able to provide a full coverage for the workers. Just now, Mr. Chan has mentioned if a worker has been online in multiple platforms, there are different insurance plans that are involved, and it covered a lot of resources from our society. It may reach to 9-digit amount. So would it be possible if we can unify and provide one standardized coverage for these workers among all the platforms so that they can actually enjoy a better coverage without the duplication of resources? Also, from yesterday, there was a company using $120 billion to purchase another company. So in such changes in the market, will there be a standardized coverage protection for the workers? Thank you. I would like to clarify that the compensation will not be duplicated, but under this new trend, as what you mentioned, a worker may work for multiple platforms. If they are working for multiple platforms and get injured, then it's easy. It's easy for us to handle. But as what I mentioned earlier, if they are under registration for different platforms, but during the period of injury, they are only serving one platform, then we need to work on the details on how to calculate the compensation and how to distribute or how to assign. It will be challenging in the calculation and the discussion on details. Next, Mr. Jonathan Leung. For these platform workers, getting protection and better coverage, it's well welcomed by everyone. But we know that the cost would be very high because the insurance company is hard to calculate the risk that these workers actually face. Because the first one, the working mode is still relatively new. The second one is it's a bit hard for them to avoid the moral hazards. But what we need to pay attention to is, as what you mentioned, we don't have to worry on it because by principle we have different measures to monitor it. But we also have a member voicing out that we should not putting the moral concern. But this is not a problem of moral issues. It's about of cost, because if we are increasing the cost, then the platforms may not be able to operate as they can't afford. And then these platform workers may lose jobs and eventually affected their salary. So is it good for this industry? Will there be any long-term measures to reduce these fake claims. So I'd like the administration should take a look into having better measures to monitor this. I think if we are able to monitor these cases, then there wouldn't be a big issue. Because I remember cases of having one moral hazard and leading to suffering from a loss of half year's profit. So thank you. Let me respond quickly. So we are talking about the moral risks, moral hazards. But it doesn't mean that it stops us from moving forward. We need to know that what we are having at the moment is not sufficient. So we need to make a step forward. But in front of changes, we are always hesitant. We often have different worries. We understand these concerns. So as I mentioned, we are looking for a balance so that the platform operators are happy and they are able to afford the cost. So, but however, the actual increase in the cost of insurance has to be decided later, because we need to know the compensation details first in order to come up with the insurance policy. So in the end, we are hoping that there will definitely be an increase in cost, but it has to be a reasonable increase and it's affordable, yet at the same time giving a better protection to the workers. So at the moment, what we need to work on is how do we set the details. So I hope that we are able to find the balance. Thank you. Anything else? Last but not least is me. I have two questions. The first one is, as mentioned in the documents, if they are working for multiple platforms at the time of work accident, the platform involved shall apportion the liability. So I'd like to know the principle of the apportion. How do you distribute the percentage? Is it evenly distributed? Is it evenly split, or how does it work? The second question is, as mentioned, the platform operators and platform workers, they are not under employment relations. So they are only bound by an agreement. So under this agreement relationship, this is about a compensation between the platform operator and platform worker. It is different from the employer relationship. So, am I understanding it correctly? And is our employment compensation ordinance applicable to this cooperation between the two parties? Maybe let me answer you this question first. What we are mentioning is what we are working now. From a higher level, under Hong Kong legislative system, one is employees, one is self-employed. Until we have this digital platform industry. This digital platform industry, they can hire these self-employed and become employees, but they have tried to avoid it. They believe that self-employer or nature is work better for their own operation. This is not limited to Hong Kong. in different parts of the world, we have this feature. So the traditional self-employed versus the newly emerged self-employed freelancers has a different job nature. So the traditional one, like hawkers, they work depends on the weather. So at the moment, the government is interfering in work injury area. We are using the legislation to protect them. But we are making clear definitions so that it's under a clear framework and it makes us more comparable to other cities or countries like Singapore. We don't see the need for judicial review. So, yeah, thank you, Chairperson.
If there are more than one platform, then of course there is the need to apportion the liability. And then a worker may have worked for the operators, and we can look at the past records of working hours, and then the compensation can be calculated according to that ratio. As to the actual details, as I mentioned in my earlier reply, we will talk to the tripartite committee, and we have also talked to the operators, and probably operators would look at all the elements in the legislation, and then they will know what to do and what sort of balance can be achieved. Thank you. The proposal before us attempts to resolve the question of work injury compensation for digital platform workers. You also have far-reaching implications for civil claims for work injury compensation. So scholars may also want to note our discussion. Mr. Lam Wai Kong, second round. If I may also refer to a particular scenario, paragraph 11 talks about compensation for adverse weather conditions. Platforms allow workers to make their own decisions as to whether they would continue to perform delivery services when there are adverse weather conditions. But then when it rains, more people would like to have takeaway delivered, while the black or red rainstorm warning signals have yet to be hoisted. But then when the rain is heavy and the workers have to deliver the food, will there be more protection for them? And then when there is hot weather conditions, they still have to run outdoors to deliver the food. So would they be protected as well? And should there be showers or rainstorms, not across the territory, but in some regions only, then will they be covered as well? Commissioner, if I understand Mr. Lam's question correctly, I think he's referring to the case when we have yet to have adverse weather conditions, but then the weather is already quite bad and the worker accepts the assignment. Well, I think irrespective of the weather, when a task has been assigned and accepted, then the worker is entitled to the compensation. When we have a high tropical cyclone warning signal. And when there are adverse weather conditions, after he has accepted the assignment and after he has delivered the service, would like to enhance the protection. That is, within the 4 hours of delivering the goods or the services, the worker will still be entitled to the compensation. So we are enhancing the protection rather than diminishing it. Mr. Lam, will there be an additional layer of protection? That is, we have yet to have adverse weather conditions, but then the weather conditions are unstable. Are you going to have another tier of protection additional to the original one? Commissioner, I need to consider what actually is to be added. Thank you. According to the paper, within the year, the administration will introduce the legislation into the LegCo. Members, any questions on this proposal? No? Then I would like to thank the Secretary as well as the Commissioner and their team members. Item 4 on the agenda. Measures of the Labor Department to promote youth employment and the Working Holiday Scheme. Mr. Ho, the Deputy Commissioner, and some other members will walk us through this paper. Members who would like to ask questions, please press the request to speak button. So, I'll give the floor to Mr. Raymond Ho, Deputy Commissioner for Labor. Please walk us through the LC paper number CB bracket 1 X39/2026 bracket 04. Thank you, Chair. Would like to brief you on our measures to promote youth employment as well as the Working Holiday Scheme. The LD for years have adopted a multi-pronged approach and formulated appropriate measures to provide all-round training and employment support for young people. First of all, let me talk about the Greater Bay Area Youth Employment Scheme, the latest progress. In January last year, we came up with enhancement measures so that we relaxed the eligibility requirements for joining the scheme to include young people aged 29 or below with sub-degree or higher qualifications. We also increased the limit of allowance for employers to $12,000 per month per young person for up to 18 months. Enterprises employing Hong Kong young people must have business in both Hong Kong and the mainland cities of the GBA, and they employ Hong Kong young people in accordance with the Hong Kong laws to work in the GBA mainland cities. This is a projection that we insist on, and we support the young people, and that's why we have engaged the Hong Kong FTU Greater Bay Area Social Services and the Hong Kong United Youth Association to provide support services for young people while they are on the mainland. The LD, via different means, have been advertising the service. Back to the figures or data. In the year 2025, especially after the enhancements, we found that it was well received. And in fact, 2,721 job vacancies were recorded, and about 600 young people joined the scheme. For job vacancies, the number went up by about 24.5% compared with 2024. So the number of young people employed compared with the year 2024, again, there has been an increase of 45.6%. I think for the youth employment and training program, I think you are familiar with it. Would like to have on-the-job training as well as pre-employment training courses. In January last year, again, we enhanced the YETP YP. Say, for example, for the age limit, instead of stopping at 24, we extended it to 29. And then under the scheme, we had the workplace attachment training allowance. And in fact, that month's allowance went up to $8,000. Last year, we tried it for the first time. And in fact, we were trying to attract young people with educational attainment of sub-degree or below. Last year, we had a 1-month workplace attachment so that those aged between 18 and 29, they have the chance to have workplace attachment on the mainland. 20 such attendees completed their 1-month GBA work experience attachment program. We'll continue to do so in Q4. That is work experience attachment for members of the Youth Employment and Training Program. Having enhanced the program for the 2024-25 program, there were about 4,000 people joining the scheme. When compared with the earlier year, 2023-24, we found an increase of 43%. Now, for the year 25-26, as of June this year, we have already got 4,000 trainees, even though we haven't completed the entire year's program. So compared with the previous year, 2024-25, we saw a continuing trend of increase of 21%. Well, for the youth employment start resource centers, 2 of them have been set up. In fact, people with higher levels of educational attainment will also be served by these centers. So it is a sort of one-stop integrated support services on employment and self-employment for young people. Now I want to talk about the Working Holiday Scheme. It was introduced in the year 2001. The purpose is to provide Hong Kong young people with opportunities to experience living and gain work experience overseas and to broaden their international horizons. The scheme was designed in such a way that young people joining the scheme could go to partner countries with which we have signed agreements. They could stay there for up to 12 months and they can take up short-term employment and or enroll in short-term courses so that they can learn about the local culture and social development of the host economies. As of end of last year, under the WHS, more than 108,000 young people from Hong Kong participated in the scheme. Currently, we have had partner agreements signed with 13 countries, and 18,000 young people from the above partner countries visited Hong Kong and joined our WHS. We'll continue to explore bilateral WHS arrangements with suitable countries to provide more destination choices for Hong Kong young people. Chair, the LD will review our relevant services in a timely manner, taking into account our economic conditions and youth employment situation. We listen to the views of stakeholders with view to providing appropriate employment support for young people. 5 would like to speak: Chang Pui Kong, Moon Kiat, Alvin Lee, Lam Chun Sing, and Ken Wong. First of all, Mr. Chang Pui Kong. Thank you, Chair. I'm sort of interested in the GBA work experience attachment pool. We would like to have the I would like to ask a question about the GBA Youth Employment Scheme. We have got more than 700 offerings, and yet there are still vacancies. Can we not raise the age limit to over 30? If those aged 20-something are not interested, Why don't we extend the scheme to those aged 30 or more? And then for the YETP, in the year 24-25, 4,000 trainees compared to 23-24, an increase of 43% in June, as of June this year, compared with the previous year, an increase of 21%. I believe that this is a popular scheme. With the emergence of AI, I think some young people will find it more difficult than before to secure a job. So I think we should enhance the resources. We should provide more subsidies so that the young people can transform themselves. They should be assisted by giving them pre-employment skills. I think this is a popular scheme with the young people.
Thank you for your suggestions regarding the GBA Youth Employment Scheme. In last January, we have relaxed the age limit and education background to more youth, so more people can benefit from the scheme. We have two main directions. The first one, we have these vacancies. We see that in different institutions, no matter it's local Hong Kong or mainland institutes, we also have done some promotions. We have recruitment, job fairs, etc. We would like to encourage more eligible candidates to join in this program. In terms of the age, we can continue to monitor and observe and make adjustments according to the development of our job market. We can make adjustment according to the development and in the right time. In regards to the job market, you've mentioned AI development. We also have some collaboration with the ERB to offer a wide variety of training courses, including some AI elements, so that we can enhance their compatibility and employability of the youth to face this change in job nature in this era. Thank you. Next, Mr. Ng Won Kit. I have two questions. The first one is the GBA YES. As mentioned, we only have 20 students or youth being employed in the first year. So may I know what are your indicators in assess the effectiveness of this scheme? And my second question is how to get more public and members to actively engage in this program. Will it be focusing more on the technology side to attract more young people? The second area is about the working holiday scheme. Since 2025, we have more than 100,000 young people from Hong Kong people. But we can see that only 18,000 young people from other countries visiting Hong Kong. We've also always mentioned about One Belt, One Road collaboration. Will there be more promotion along these areas? Thank you. Thank you, Chair. Thank you. Regarding the first time of having the Great Bay Area Youth Employment and Training Program under the GBA Work Experience Attachment Program. Since their education level is lower, it's below associate degree, they still get the experience of working as an intern. We believe that this actually imposes a positive learning experience to them. So we are planning to implement it again this year. We are preparing for the recruitment and promotion this year. So we are going to promote it through different channels so that they know about our scheme, hopefully to attract more students and youth to join this program. We also would communicate with different corporates or industries to share what we are offering at the moment so they can engage more in these programs to engage our youth. Regarding the working holiday scheme, there are two directions that we are working on at the moment. We are for sure discussing the One Belt One Road countries on the working holiday schemes. We are doing promotion via our Hong Kong offices stationing in different cities around the world. We hope that through these stations they can communicate with the locals there to learn about the working holiday scheme. We are extending our meeting time for 15 minutes to 10:45. Next is Mr. Alvin Lee. These are great plans, but with the influence of AI, and the development of our society and the change in job natures, we need to consider these and make adjustments. I have a few suggestions regarding the programs here. Regarding the YETP, we have the training and pre-job training, pre-employment training. I would like to ask about whether there are any matching service, because some industry may lack some new blood or new young people to join in, such as the hotel industries. Will there be any measures for this matching service so that our industry are getting enough employees? Regarding the GBA experience about the promotion and participation, I'd like to ask more on the salary and how they're able to adapt to the experience, etc. The effect on the corporates, how they're benefiting from it, etc. Number 3, regarding ERB offering a wide variety of pre-employment training courses, will there be adjustment in the resources? Thank you, Chairperson. In terms of the entire youth employment trend, including the AI development, our government also believe that we need a monitor. We also believe that we need a review on analyzing the influence on AI on the job market. In Q4 this year, we believe that we can offer some new statistics and data to share with the Legislative Council members. Regarding this phenomenon, we need to work with youth-related organizations to understand their concerns and directions. Maybe there are more what are their needs, etc. At the same time, we will also contact some industries that would be more attractive to young people to discuss on the plans to engage the youth. Collaborating with our training organizations, we also will tailor-made some of the trainings for them so that they could enhance their employability. Regarding our youth employment start, the whole Labor Department youth employment work, we are doing an overall review. We have a direction and a goal to target to youth until 29 years old. We want to see how can we help them in a more comprehensive way. Is it a pre-employment training, on-job training, or other areas support? So via our youth employment start, we hope that we would be understand their needs more and see how our ERB can support us in this way. So this is our direction at the moment. Mr. Lam Chen Sheng, thank you. Regarding working holiday scheme, we have 14 countries at the moment. In 2019, we have added the new country, Netherlands. But in these recent few years, we don't have any new countries joining. So will there be any new possibilities to collaborate with, especially in the One Belt One Road countries? As what the administration mentioned, that we hope that we can share some of the results from this exchange programs. Regarding the yes, we see that the number of participation has been changed. But now it's a different era, so the need could have changed. Even now, secondary schools offer applied learning. So we have started the vocational training earlier. So will our government, or especially EDB, has offered some vocational training already? So they are not joining our youth employment training program. Our YETP program, although we have education elements, but it's more focusing on the vocational training part. But with the lower usage at the moment, will it be possible to review this to see if it should collaborate with other organizations or departments so that the resource can be better utilized to help our youth? Is there a need for review? Maybe I should declare our organization has also run these YETP programs. Thank you. Thank you, Mr. Lam, for your suggestions. As mentioned earlier, for the working holiday scheme, we have actually closely working with some potential countries to have some new countries options, to have some new plans, hoping to launch. In between these few years, we are affected by the COVID, but at the moment, we have a few countries along One Belt One Road that are interested in our working holiday scheme. So we hope that very soon we can share with the public our new schemes. As you mentioned just now, for our YETP, there are different factors regarding our youth population or our training opportunities has enhanced. So there are different factors affecting this. We agree that we should review our resource putting on youth employment. We would like to see what are the most suitable needs for them, and so we can provide support to that. We are paying close attention to it now. For example, we have collaborated with the ERB. We actually have putting the employment training we have assigned it to the ERB already. So we try to avoid the duplication of resources. So with this, we can enhance the training providing to the youth.
Just now I said that I would draw a line after Lam Ching Sing has spoken. Mr. Ken Wong, other than providing pre-employment training and on-the-job training, can we not be more systematic? That is, try to look at their job or their career development by having a longitudinal study, their employment rate and the rate of staying in the same job, so that we can monitor the development of young people in the labor market. Commissioner, thank you for Mr. Wong's question. Well, there are two programs here. There's the GBA Youth Employment Scheme as well as the YETP. For the GBA YES, we are interested in the following. After the young people have taken up a job, we will continue to contact him. We'll see if they need any assistance for their life on the mainland, and would like to know, upon completion of the 18-month period, how many of them would stay in the same job. We do encourage the enterprises to keep the young people instead of just finishing off the 18-month employment contract. That's not our design. The purpose of inviting young people to join the scheme is such that if both parties find it agreeable, the employment should continue. So we have got the longitudinal study lasting for 3 years. We'll try to track the participants who join the scheme. We'll look at their developments over the span of 3 years. The study is still underway, and once we have completed the study and once we have analyzed the data, we'll come back to the panel to report to you about findings. For the YETP, it is a regular program. We have got training bodies, and through them we can understand what happens, like whether the trainees continue to be employed by the same employer or whether they will go to the labor market and look for a new job. In fact, some trainees would choose to continue with the study. So we would like to find out about what happened to the young people upon completion of the program. Mr. Chung Pui Kong, Mr. Lam Wai Kong, my organization also offers training places. Well, for the GBA scheme, I understand that the administration would like to emphasize AI, innovation technology, as well as international shipping center. That would be the focus of our developments. So would your employment schemes echo such directions? The mainland has got academies on shipping. So can you not provide a longer workplace attachment program so that young people can get more work experience and come back to Hong Kong to serve our economy? That's the first question. Second question is about the youth employment start. It is an integrated support service center on employment and self-employment. Recently, we've noticed that fresh graduates have found it difficult to get a job. For AI applications, some of them are not that familiar with AI applications, or the lack of work experience is a factor why employers don't like them. So are you going to take that into account and try to address the problem faced by fresh graduates looking for jobs? Deputy Commissioner, I would like to thank Mr. Lam for his questions. For the GBA YES, before we launched the scheme proper, there was a pilot scheme. I think you would recall that as far as innovation technology was concerned, there was a different amount of allowance given. We analyzed the findings of the pilot scheme. We thought that the size of the allowance should be standardized, provided the enterprises are meeting our requirements. And in fact, the allowance has been enhanced. We believe that there's a proper way to go about it. We're grateful to Mr. Lam for saying that we should bear in mind in emerging industries like the AI enterprises, etc. We will try to talk to such enterprises and try to see if they can have more openings for our young people under the scheme. In this way, young people who are interested, who are resolved to join such careers can take part in the scheme. For AI, it is going to be a game changer for many industries. For some positions, some job positions, they may be affected, but at the same time, AI may create new jobs. We need to adapt to the new era of AI. What is important is that for youth employment start, we have got training courses. For every quarter, we come up with new courses in the light of developments in AI technology, like AI applications, etc. So what is important is that we hope young people would have access to AI and they know how to apply AI, and then we can enhance the employability, and then they will be assisted in getting a job offer and staying in the job. Thank you. Mr. Chan Pui Kong for the second time. Thank you, Chair. I'll be brief because probably my question has been answered by the administration. Let me just check whether there is anything to add to the replies. Well, employers get a subsidy of as long as 12 months for taking on board a young trainee. I want to know how long. I want to know about the retention rate. We want to know about the what happened to the young people, whether they keep their jobs or whether they continue with the studies after they have completed their work experience attachment program or their on-the-job training program. Thank you, Chair. Thank you, Mr. Chung, for your question. For the YETP, we did carry out surveys. For the on-the-job training, it can last as long as 12 months, and then we'll talk to the trainees to find out what happens. According to the latest information, 70% of the trainees are being employed. More than 10% of them have got other sort of developments, like continuing with their studies. So we do believe that the program is helpful in their employability. So all questions have been answered. I would like to thank the Commissioner and his team. Nothing under AOB, so meeting adjourned. Thank you.